Hi, everyone, and welcome to episode 9 of Terpenes and Testing, the podcast. This broadcast is brought to you by Mace Media Group and Terpenes and Testing magazine, the industry's first publication dedicated to cannabis science. I'm Jason Lupoi, and I'm the editor-in-chief of Terpenes and Testing magazine, and I'll be your host as we navigate across the landscape of cannabis and psychedelic science. I'm here in Western Pennsylvania, and Western Pennsylvania can be a strange place for discussing cannabis. The infamous Harry Anslinger, popularizer of the term marijuana to highlight supposed racial connotations with cannabis, is from Western Pennsylvania, just a few hours outside of Pittsburgh. In Jack Herer's book, The Emperor Wears No Clothes, Andrew Mellon of the Mellon Bank of Pittsburgh is pointed to as the chief financial backer of DuPont, makers of synthetic fibers in competition with hemp. Even the Fed's Operation Pipe Dreams, an effort to target businesses selling drug paraphernalia like bongs, had a Western PA theme. And many of the cases were filed in Pennsylvania, including one against Tommy Chong. There were 55 indictments, and 54 of the people received fines and home detentions. But Tommy Chong was who had been pressured into selling bongs to a fictitious head shop in Beaver Falls, Pennsylvania, received a much stiffer sentence, including having to serve 9 months in federal prison. The feds admitted that they enforced a stiffer sentence against Tommy Chong because his movies made light of law enforcement efforts to stop cannabis. So for this episode, I wanted to speak with Pittsburgh attorney Patrick Nightingale, who is the executive director of the Pennsylvania Medical Cannabis Society and a partner at Cannabis Legal Solutions. Patrick began his legal career as a prosecutor with the Allegheny County District Attorney's Office in 1996. And since 2002, he has specialized in criminal defense with a particular focus on protecting the rights of cannabis consumers. In 2009, Patrick reestablished the Pittsburgh NORML chapter after the introduction of Pennsylvania's first medical cannabis bill. And since then, he has spoken extensively on the subject of cannabis reform. He's also been privileged to testify on numerous occasions before Pennsylvania legislative bodies considering medicinal cannabis legislation. And in 2015, Patrick joined the Pennsylvania Medical Cannabis Society, now serves as executive director. And then in 2017, he and his partners established Cannabis Legal Solutions, a law firm catering to the needs of Pennsylvania's emerging medical cannabis industry. Patrick, welcome to the show.
Thank you very much, Jason. And it is an absolute privilege to be able to speak to you and to your audience about the issue of cannabis reform here in the Commonwealth of Pennsylvania and in the United States of America.
Excellent, because I have a lot of questions for you. So I'm going to dive.
Ready.
Okay, so I guess at first I just wanted to hear how you got started with cannabis law. How did you go from being a prosecutor in Allegheny County to getting involved in cannabis?
Yeah, it sounds kind of funny to talk about, but it literally goes back to when I was in high school. As a high school student, I was a cannabis consumer in the 1980s. And I was also in a YMCA program called Youth in Government. And I had the opportunity to participate in national affairs. And national affairs required us to advocate for some type of national legislative reform that we thought was important. And being a bit of a smartass, I chose cannabis legalization. And that's what led me in 1987 to reach out to NORML, the National Organization for the Reform of Marijuana Laws. And they gave me a lot of information that debunked a lot of the prevailing attitude in the 1980s. Cannabis kills brain cells. Cannabis is a gateway drug. And that kind of opened my eyes as a teenager. And it is something that stuck with me throughout my career, both as a prosecutor, as a criminal defense attorney, that a lot of what we have been told, a lot of what we have been sold as cannabis as a Schedule I controlled substance with no medical efficacy, with a high potential for abuse, is, to be honest with your audience, and forgive my language, utter fucking bullshit. And it astounds me that here we are in 2022, that we are still addressing issues associated with cannabis as a Schedule 1 controlled substance when it was never ever intended to be there. Its Schedule 1 controlled classification was merely an accident, and yet the DEA and Congress has doubled down and will absolutely refuse to reconsider it. And here we are. And cannabis's Schedule 1 classification continues to have a significant impact on Pennsylvania medical cannabis patients. And at the moment, the path forward to either deschedule or reschedule is mired in partisan politics. And, Pennsylvania cannabis consumers, suffer, or all cannabis consumers, whether you're in a medical state or an adult use state, continue to suffer the results.
Absolutely, Patrick. I love it. I think you might have also taken us to an R rating on this show, but
I apologize.
That's certainly fine. That's certainly fine with me, because you segued right into a question I had for you, and I was looking into as always, I'm completely baffled by Schedule 1 and the hypocrisy that its definition, places on substances like cannabis, psilocybin, and peyote, all ethnobotanical plants that are surging in public interest right now and in medical interest because of their known medical values and the fact that they're not highly addictive. And then when you look at, I found 3 drugs in particular, pharmaceutical drugs: Xanax, OxyContin, and Fentanyl are Schedules 2 and 4. And my question for you was, what are your thoughts on this? But you've already delved into that.
Yeah, it's absolutely absurd. I remember doing an interview with someone in the media, and I said, cocaine is Schedule 2. And the media personality was outraged. I'm like, how can you say cocaine is Schedule 2? It's highly addictive. I'm like, yes, but it also has medical benefit because it can ease in the intubation of someone who needs to be intubated for breathing purposes. And this interviewer was absolutely astounded that cocaine, which we understand has the potential for serious addiction issues and can be converted into crack cocaine, which is also a Schedule 2 controlled substance, was not what was Schedule 2, while cannabis was Schedule 1. And what I tried to emphasize is that cannabis was never intended to be a Schedule 1 controlled substance. It was placed in Schedule 1 temporarily, awaiting the results of the Schaefer Commission. And for the audience who may or may not be aware of this, at the dawn of the war on drugs, at the dawn of the Controlled Substances Act, President Nixon tapped former Pennsylvania Governor Raymond Schaefer and said, "Hey, Ray, we've got to figure out, just how dangerous marijuana is. So we need you to chair a commission, and the commission is going to tell us whether marijuana should be Schedule 1, 2, 3, 4, or 5. In the interim, it was temporarily placed in Schedule 1. And even Nixon's deputy health advisor, Dr. Roger Erberg, I hope I'm pronouncing that right, said this is merely temporary, and we're awaiting the results of congressional findings on just how dangerous marijuana is. Well, Governor Schaefer and his commission did their work. They did their due diligence. They did their studies. They looked at the history of cannabis use. They looked at how it was being used currently in the United States of America, and they recommended to President Nixon and to Congress that it should be regulated, that personal use of cannabis should be regulated in a manner similar to alcohol, and that criminalizing it pursuant to the Controlled Substances Act was simply unreasonable and did not have any evidence to support it. And Nixon said, "Thank you very much, Ray. We're not going to do that." and the report was buried, and it has been Schedule 1 ever since. The point being is there was never any congressional findings in 1970 that supported the idea that marijuana did not meet Schedule 1 classification, that it had no medical efficacy, a high potential for abuse, and it could not be medically administered under the support of a medical professional. And we now know, and we've known for years and decades, that marijuana has been consistently used as a medical treatment. Its first use was 2,900 years ago in China. It has been used throughout ancient America and throughout ancient times, and more recently, it has been used in the United States in the 19th century as a highly utilized treatment for a variety of medical issues. It was marketed to Civil War veterans coming back from the Civil War. Cannabis extracts and cannabis tinctures were advertised and produced by all of the existing pharmaceutical producers at the time, like Eli Lilly and so on and so forth. And then suddenly in 1937, it was stripped because of the Marijuana Tax Act that was advocated by the director of what was the predecessor of the DEA, Harry Anslinger, who decided that for political purposes and economic purposes, he was going to criminalize and demonize marijuana, which no one had ever actually called it marijuana before that time. And the next thing you know, we've got reefer madness, and marijuana is leading to violent crime and so on and so forth. And that's the backdrop that led to its Schedule 1 classification.
Right. And it's 50 plus years now since that Schedule 1 classification that people have not been able to, a lot of people, at least some places, have kind of woken up from their slumber and realized that the plant has, a lot of validity in one's life. And I think that it's tragic. I often wonder how many people, like if you could put a number on it, how many people could have benefited from this plant or downstream products over that amount of time that it's been demonized.
Yeah, it's staggering to consider the overall economic effects of prohibition. And when I say economic effects, this is what I'm talking about. You're 18, you're 19 years old, and you catch a possession charge. And that's on your criminal record for the rest of your life, unless the governor pardons that. So now you're looking to try to get student loans to go to college, to get an advanced degree. And they say, oh, wait a second, you've got a drug conviction possession. We are not going to give you student loans. All right, so now you're trying to get jobs in the general workforce. And an employer says, oh, wait a second, we see that you have a drug conviction, not distinguishing between marijuana, heroin, cocaine, methamphetamine, prescription pills. And so an individual with even a simple possession conviction now has their economic opportunities significantly rescinded, and their ability to contribute to our overall economic or consumer-based economy is significantly restricted. And if that was, one or two people, okay, that's not so much of a big deal. But we have literally millions of American citizens that have a simple marijuana conviction that restricts or impedes their ability to be full participants in our market-based economy. So we're literally shooting ourselves in the foot by saying, hey, we're not going to give you an advanced degree. We're not going to give you student loans. We're not going to give you jobs in manufacturing because of a simple misdemeanor conviction you have from 20 years ago. It is doing a significant disservice to the economy as a whole. And what we are seeing now in states that have full adult use reform, that employers are no longer testing for cannabis because they know that they're losing a valuable pool of potential employees by saying, hey, if you're a cannabis consumer, we're not going to bring you on board.
Yeah, absolutely. And I think that reefer madness that you were discussing, I like to think that it's evolved into a sense of mindfulness with people within our industry. And I think that one thing that I've seen is this sort of systematic driving of the nails into the coffins of all the misconceptions about cannabis. And one of them, I think, is that people that are using cannabis are not productive. They're the trademark, Spicoli teenager, this not of use to society. And there's been some studies recently that have been interesting in that from what these limited studies have discussed, there hasn't been an effect on one's performance at work or one's creativity, or it's actually stimulated that.
Well, what scares me is that there is nonetheless a backlash from employers, from manufacturers, and that is embodied in a bill that's working its way through the Pennsylvania Senate right now, Senate Bill 749. And Senate Bill 749 is what I would refer to as an anti-employee bill, a pro-employer bill. And what Senate Bill 749, among other provisions in it, would allow an employer in what was considered a safety-sensitive position, which is very loosely defined, and to me would include any construction or manufacturing position. It would allow an employer to make a good faith determination that an employee was under the influence of cannabis, and it was up to that employee to rebut that. Otherwise, they would either be subject to discipline or termination from their job. So think about that for a second. You've got a supervisor, a shop steward, you've got a manager who decides, hey, I don't like the fact that I've got someone who's using medical marijuana in my job, so I'm going to make a report that I think that person was high, and they can be fired or disciplined unless they can rebut that with a negative drug screen. And a drug screen is going to demonstrate that they at least have carboxy THC in their system.
Right.
So what I am terrified about is that while Pennsylvania moves forward in some respects, it is moving backwards in terms of employee rights, housing rights, potentially custody rights. The best I can phrase it is a conservative backlash against the advancement of cannabis consumer rights and cannabis employee rights is resulting in what I think is very, very, very bad public policy. If Senate Bill 749, gets through the Senate, gets through the House, and makes it to the governor's desk, and we are prepared to, fight hard for the governor to veto that.
Wow, I did not know that, and I'm curious if that bill, or maybe there's already a bill or like a law about prescription drugs and the same safety aspects on jobs like you were mentioning. Is that in there, or is there a Pennsylvania?
No, nothing at all. It is specifically about cannabis, and it specifically enables employers to discriminate against medical cannabis patients, regardless of whether or not they're actually using cannabis at the job site. And Pennsylvania law already says that an employer is not required to accommodate medical cannabis use on the job site. So what is the issue? The issue, in my opinion, is to give employers the ability to discipline and terminate medical cannabis patients who are not using cannabis during the workplace on very, very specious grounds of alleging impairment, and then saying, "Oh, wait, you've got trace levels of delta 9 THC, you've got carboxy THC, therefore we know you've been using marijuana and we can terminate you." And to me, this goes against the prevailing trends in other states where we see increasing use of, for example, workers' compensation covering the cost of medical cannabis products, increasing workers' rights in other states. Here in Pennsylvania, it seems that our Republican majority wants to restrict those rights as much as possible and make it as difficult as possible for a medical cannabis patient to literally be a normal, productive citizen in the Commonwealth. I see this in DUI reform, where we are advocating and have a bill in the legislature that would treat medical cannabis the same as a Schedule II or Schedule III prescription non-narcotic, requiring proof of actual impairment. Right now, a medical cannabis patient or any cannabis consumer can face a DUI arrest, prosecution, and conviction merely for having non-psychoactive metabolites in their bloodstream. Law enforcement knows this. So if law enforcement encounters you and says, "Oh, you're a medical cannabis patient," well, I know you're going to at least have carboxy THC in your blood, the non-psychoactive metabolite of THC, and that is sufficient to jam somebody up on a DUI. And as ridiculous as that sounds, we cannot get a bill moving through the General Assembly that would protect the rights of medical cannabis patients, simply requiring proof of actual impairment. So here in Pennsylvania, while we have made significant steps moving forward with our medical cannabis law, while our governor, our lieutenant governor, and the Democrats in the House and the Senate all fully support cannabis reform, we are hamstrung because the Pennsylvania Republican Party holds the majority in the Senate and the House. And if they do not want legislation to move forward, it simply doesn't move forward. And we can't get even simple common sense reforms such as DUI protections for medical cannabis patients without the Republican Party, signing on to it. And they simply have not. I don't understand it. It frustrates me. It infuriates me. It pisses me off. But here we are. We're stuck with the realities of Pennsylvania. Pennsylvania moving forward in some respects. Pennsylvania taking multiple steps backwards in other respects.
Right. And I, with the subject of the DUIs, a lot of the studies that have been done on cannabis and driving. There was an old one, I want to say it was in the 80s, from the Department of Transportation. And there's been others that have really not shown cannabis to be the same kind of factor as alcohol is. And we recently did a blog about, there was a study that talked about the amount of lane swerving in some driving simulation, and that when THC was present, there was more of a lane swerve than when THC and CBD were used together, or if CBD was used by itself. And what was interesting was we did a deeper dive into lane swerve evaluations of impairment, and we looked at lane swerve data for legal limits of alcohol, and the lane swerve was more than the lane swerve from THC. And so, the question was, well, how can THC be considered impairing your driving if the legal limit across the board in the United States, including in Utah, which is much stricter, if that led to more of a lane, I think they used some unit of measurement like millimeters or microns, something to that effect, and THC was lower than the amount of lane swerve from alcohol. So there's really never been evidence of what impairment means from a cannabis perspective that I've ever seen.
Well, to me, law enforcement is well equipped to detect and evaluate drug impairment, cannabis impairment, alcohol impairment. The issue here that we have in Pennsylvania is they don't have to prove any of that. They don't have to prove impairment whatsoever. You can get a DUI in Pennsylvania if you are stone cold sober, if you have carboxy THC in your blood, and law enforcement knows that. Now, how would law enforcement, suspect that you have carboxy THC in your blood? It's if you inadvertently admit that you are a medical cannabis patient. And at that moment, law enforcement knows, oh, you're a medical cannabis patient, then we know you're using medical cannabis, and we know you're going to have, at the very least, carboxy THC, and we can jam you what I call manufacturing a DUI, because they know that there will be at least non-psychoactive metabolites that is, under Pennsylvania law, sufficient for a DUI. So all we are asking is to require proof of actual impairment. And that's when, some of the issues that you bring up can become 100% relevant. What does, 10 nanograms per milliliter of Delta 9 THC mean? Does that mean someone was high? Does that mean someone was impaired? Is that something that we can correlate with blood alcohol levels? Whatever. Just give me the opportunity to argue that, to present testimony in court, instead of, okay, it's been 2 weeks since you consumed cannabis, but you've still got, 15 nanograms per milliliter of carboxy THC. So we're going to arrest, prosecute, and convict you of a DUI under Pennsylvania law. And to me, that is probably the most important issue facing Pennsylvania medical cannabis patients, with the high cost of medical cannabis products being number two.
Yeah, absolutely. And it's, it's interesting because, listening to our conversation, it seems hard to believe we're talking about a plant, but, it's startling to hear that there's still these things going on in Pennsylvania and maybe in other states. And one of the things, before we run out of time here, one of the things I really wanted to talk to you about was Pennsylvania sending out those mass emails to medical patients saying that some of the products they were ingesting may be harmful. And, I had been seeing products on the market that clearly were not, flavors and aromas from a cannabis cultivar. There was things like root beer and cinnamon, and, if you tried it, it was quite obvious that it was, a flavoring. And those kinds of molecules, some of them are not meant to be inhaled. They're fine if you eat them, but they're not meant to go into your lungs, like some of the things that make cinnamon flavors. And what I found interesting about that was the state has always said you cannot smoke cannabis, because, and we talked about this before, that it was kind of an appeasement to conservatives who felt that you don't smoke medicine. And I think there's some debate there on that too. However, that's what they chose. And it was just guys like it was for our health. And then here we are 5 years into the medical cannabis program here. And all along, the state indicated that a grower processor would have to get written permission to use excipients like these ingredients. And it's either apparent that the state gave them the permission to use them and didn't research any of the health ramifications of inhaling these substances, or they just never gave them permission, and these grower processors did it anyway. And I was curious what your insights on that are.
Yeah, my insight is from a patient perspective. They terrified the Department of Health with this blanket announcement, terrified consumers, and did not provide any reason or evidence behind why they said this. So you have Pennsylvania consumers who have been using these products, and I agree with you. I don't want to use something that's got non cannabis terpenes introduced as a flavor to it, but that was something that has been happening in other states in adult use marketplaces. But to come out with a blank prohibition has led the patient community to literally freak out. It's like, hey, I like this product. Now, am I suddenly at medical risk from it? And the Department of Health, did not provide any insight, any evidence. And in fact, I don't believe there is any evidence that any of these products had adverse effects. So if the Department of Health is going to issue such a comprehensive statement that these products are no longer available, I think it's incumbent on the department to issue significant findings to the cannabis consuming population to say this is why we are going to remove these products from the marketplace. I know the Department of Health is getting sued over this, and that's something that could potentially result in costs of litigation being passed down to consumers in the grand scheme of things. But I think it is very irresponsible for the Department of Health to come out just blanketly saying we are going to issue a prohibition on all of these products that patients have been consuming without a well researched and documented explanation as to why. And I think that is some of the issues that Pennsylvania patients have with the Department of Health, that it just doesn't seem that the Department of Health has the resources to adequately address patient concerns. And this is an excellent example of why.
Absolutely. Patrick, I want to thank you for joining us today. As always, you've got me fired up, and I appreciate you sharing your legal expertise with us. And I think as we evolve as a human species, it's clear that we need to pull our heads out of the sand when it comes to natural plants like cannabis, and demonizing and penalizing people for trying to make their lives even just a little bit better. And so I thank you for representing people who need a helping hand in defending themselves to the remnants of reefer madness.
Hey, it's been a great conversation, and as always, I stand at your disposal for anything that you need.
Thank you again, Patrick, and thank you everyone for tuning in. We'll see you next time on Terpenes and Testing, the podcast. Until then, please come visit us at www.terpenesandtesting.com or on one of our social media platforms. Cheers.